Hi, this is Harry Margolis, and today's lesson in Estate Planning 101 is about your will. And as the will is really the basic document of estate planning. You probably that's probably what a lot of people think about when they think about estate planning. And what it does is a couple of things. While it says who will get your stuff when you die, probably the most important thing it does is it appoints your personal representative, who's sometimes called your executor or your executrix, to really handle the process of taking care of your estate. And that doesn't involves a lot more than just um, transferring ownership of property to whoever you name as your beneficiaries. The person who steps into this role has to deal with all the loose ends of your financial and legal life. So that means they have to pay bills. If you have a house or an apartment, they have to clean it out. If they have a house, they may have to sell it. If you have an apartment, they're going to have to deal with terminating the lease and dealing with the landlord. If you have tangible items, I mean, everybody I guess does have tangible items, they have to deal with them. So tangible items are anything you can touch. So that's your furniture, your clothing, your silverware, your jewelry. Your car is considered a tangible personal item. And they have to be distributed in a fair way to whoever your beneficiaries are. And it's a lot harder sometimes to deal with tangible personal property than other assets, because a bank account can be split equally between three different people, for instance. Well, your tangible assets can't be split up. So different people are going to get different things, and it has to be done in a fair way. You may or may not have left instructions for how to do it. So that's a big job for your personal representative. Then they have to consolidate all your savings and your investments and distribute them as your will says. And they have to file your final tax returns. So it's a big job to some extent. You may not wish it on anybody, um, but it's always people sometimes vie to be appointed because it is something of an honor to appoint somebody, but just make sure you appoint somebody who is organized, will follow the rules, will follow through on all the work, and will be fair and will be perceived as fair by the other people involved. So one interesting thing about the will is it only governs what's called your probate property. So if you have a trust property that when the trust says who's going to get the property, then that does not come into your probate estate. If you have IRAs with named beneficiaries or other accounts with named beneficiaries, or if you have jointly owned accounts or jointly owned real estate, that all passes according to the joint ownership or according to the beneficiary designations. And even if the will says all your estate goes to Charlie, and your IRA says the beneficiary is Sally, Sally is going to get that IRA, not Charlie. So it's important, number one, when you're doing your planning, to have all of that coordinated. And it's also important um, to think about that when you do your will. So to understand what the will actually governs and what it doesn't govern. And in some cases, the will actually governs a relatively small part of your estate. And that's often a distinction between what's called the probate estate and the taxable estate, though very few people have to pay federal estate taxes these days. If you don't have a will, then all this gets taken care of by what are called the rules of intestacy. So every state has its own, in effect, a will for people without their own wills that says who gets what. And typically it says that everything goes to if you're married, to your spouse and children. If you're unmarried and you have children, that goes to your children. If you have neither a spouse or children, then it probably goes to your parents. And then everything goes to your closest relatives in the family tree. Now, if you have an Ozzie and Harriet family where you were married once, you have three perfect children, and everybody gets along, the rules of intestacy probably work for you. Um, but if that's not you, and it's more and more it isn't people, then the rules of intestacy probably won't work. So if you're not married, if you were married but got divorced and are now a partner with somebody else, then the intestacy rules are not going to work. If you have a blended family where you brought together children from two separate marriages, the rules of intestacy will not work for you. So those are all situations where you really do have to have your own estate plan that includes a will and perhaps a trust. So those are the basics of the will. If you have other questions or would like more information, you can find information on our law firm website at margolis.com. And we have information about all sorts of estate planning issues at askharry.info. And if you post a question there, I will answer it. Thank you for joining us for this lesson in Estate Planning 101.